is being recorded and will be shared after this presentation, as this is part 2 of a multi-part training series on continuum of care program basics. This specific training is on part 1 of some compliance basics. This training is intended for folks who are currently operating a CoC program in the balance of state. If that is not you, you are welcome to stay. I just don't know how relevant this information is going to be to you. With that, just a couple of housekeeping items. Again, this is going to be recorded and we will share that. We'll also share the materials in that follow-up email as soon as that is available to us. And we have a lot of content to cover today. We're going to move pretty quickly. So if you have any questions, please feel free to drop those in the chat and we will take them as they come. We'll also have some time at the end for Q&A. But again, we have a lot to get through and not a lot of time. So thanks again for coming to today's training. And we will go ahead and introduce ourselves really quick before we get into the content. Hi, hello, I am Hope Rogers. My pronouns are she, hers. I am the CoC Performance Manager with Texas Homeless Network. And I'm joined today by Axton and Jim, who I will let introduce themselves.
Yeah, hi, I'm Axton Nichols. I'm the CoC Performance Coordinator.
Hey everyone, Jim Ward, THN Director of Planning.
Thanks, y'all. And we'd love to hear from the folks in the room. If you want to share in the chat your name, your organization, and the community that you're in, we'd love to just get a pulse of who is with us today. So moving right along, in today's session, we're going to take just a minute to talk about the public comment opportunities that are upcoming, and then we're going to move into enrollments and assessments within the CoC program. We'll talk through terminations and grievances and what that looks like, and then really the bulk of today's presentation is going to be on documenting eligibility, and then we're going to share some resources and have some Q&A time. So with that, I'm going to hand it over to Jim to talk about public comments.
Yeah, thanks, Hope. So I did want to just take a moment and let everyone on this call know that we have several policies up for public comment right now. That THN or Balance of State Public Comment Portal can be found on our website. We'll get the link in the chat here in a minute. But there are multiple that are related to the continuum of care program competition, specifically the ranking policy, review and scoring policy, our CoC's reallocation policy, and conditional inclusion policy. None of those are new. However, they have been updated to reflect kind of the 2023, meaning they were previously pointing to staff that no longer work at THN, or the policy has changed and the board is hoping to go in a different direction. So some of them have some pretty significant revisions. For example, the reallocation policy. Others, like the review and scoring policy, are really just grammatical and updating language. Additionally, we have what we're calling a significant change policy. So the significant change policy is something that would be applied in the event that a funded or a continuum of care program funded agency believes that they have identified a need for a significant change to their grant agreement with HUD, and the CoC's process to support that change or not. Currently, that responsibility has lied historically with staff. We're hoping to move that away from a staff-only responsibility and spread that amongst the committees and the CoC board, just to promote transparency for all parties. So that's really all I wanted to say there. The public comment portal, those comments, those policies will be up for public comment. They're open now. They will be open through March 29th for the first round of public comment. So if you have any questions about the policies as you're reading through them, I'm the point of contact for all 5. So if you have any questions, please feel free to reach out to me directly. And I hope that current recipients certainly take the opportunity to read them, and at least the summary documents. So each policy has a summary document associated with it that kind of talks through the revisions that are proposed. So I would encourage everyone to at least read the summary documents up on the website. And with that, I'll pass it back to Hope.
Great, thanks, Jim. So diving right into today's content, we're going to start with looking at the enrollment process and what this generally looks like. So this is the flow that we would typically expect to see, starting from identification to moving into housing. Oh, I lost. Sorry, give me just a second. I'm having some trouble on my end with my view. Can folks still hear me?
Yes.
Okay, I can't see
It's still projecting.
my panel view.
Hit escape.
Sorry, y'all, give me just a second to reconfigure.
While Hope's doing that, I'm going to go ahead and drop the slides in the chat.
All right, I still can't see my normal view, but we can make this work. So getting back on track, this is generally what we would expect program enrollments to look like, and the flow that we would typically expect to see. So starting with coordinated entry, it is a requirement that all participants enrolled in CoC funded programs have a coordinated entry enrollment or the equivalent domestic violence workflow. And taking that a step further, we expect that folks that have not only been enrolled in coordinated entry, but have also been referred to your housing program through the coordinated entry process. This can be done in or outside of the coordinated entry workflow. It is built into the workflow, so I always recommend doing it there. So that you don't have to come back and do that later. But this should follow the coordinated entry process used in your local community, recognizing that processes may vary slightly by community to community. So assuming that you have a program vacancy, once a client has been referred to your program through the coordinated entry enrollment, generally the next step is reviewing and completing any intake forms. And then from here, staff should be gathering information to determine the client's preliminary eligibility. This is a lot more complicated if you are a PSH provider than a rapid rehousing or a joint TH or rapid rehousing provider, which I'll refer to as just joint providers. Typically, this starts with engaging in a conversation with the person seeking assistance about their housing and homelessness history, and then gathering or beginning to gather or request their eligibility documents. And then from there, we go into the required notices. So before a participant is formally enrolled into the project and receives any assistance with CoC funds, projects are required to provide several notices to participants, including termination grievances and VAWA, or the Violence Against Women Act. We'll be talking more in depth about termination and grievance in this presentation. If you have specific questions about VAWA or what that policy would look like, we're happy to take those questions or provide you copies of some sample policies of what that would look like. And so this is that the required notices is satisfied through providing them copies of these policies and procedures that are signed and dated by both the participant and the staff enrolling them. And when I say providing them copies, I mean providing them copies after having a conversation with them and explaining what they actually mean to them. So informing them of their rights in the program before they are formally enrolled in the program. And projects should be retaining copies of these notices or a receipt of these notices within the client's file, in addition to providing that copy to the participant. And then from here, typically the next step would be to formally enroll them in your project in HMIS, and then conduct a formal eligibility determination through the review and verification of eligibility documentation. Again, this is a lot more complex for PSH providers, but still just as important for other project providers. And then we get into the fun part of housing search and identification and lease up. Lease up is really a multi-step process and includes, conducting a housing quality inspection, determining and documenting rent reasonableness, things of that nature. We'll be talking a lot more about those specific items in our training next week. So I would highly encourage you to come back the same time next Thursday to learn more about that. And again, if there are any questions in the chat as we are moving through this, please feel free to share them. And with that, Axton is going to take us through the assessment process.
All right, yeah, hello everyone. So HMIS assessments. So kind of building off of the previous slide, when you're doing the enrollment in a project in HMIS, the workflow is going to walk you through at least an intake assessment. So the HMIS assessments are generally collecting information about like living situation, income, barriers, like health or health conditions, or disabilities, and like health insurance. So that's generally the type of information that's included in these assessments. So when do these assessments occur? So of course, when you enroll a person, there is going to be an intake assessment that you complete with them. And then also when a client is exited from a project, there will also be one of these assessments completed. But then the one that's easiest to overlook or forget would be the annual assessments. So any client that has been enrolled in a project for 12 months is required to have an annual assessment. You have a 60-day window to complete that annual assessment. So it can be completed 30 days before that year mark or 30 days afterwards. But it is important to get those assessments completed. It's also possible to update information related to, like, again, living situation, health insurance, income. You can update that information during program enrollments using a during program enrollment update. So you're generally going to want to do a during program enrollment update anytime there is a change in housing status or income or cash or non-cash benefits. The annual assessment is separate from the during program enrollment updates. So even if you recently updated a client's income with a during program enrollment update, you're still going to need to complete the annual assessment when that comes around. So it's really up to projects to stay on top of completing those annual assessments. There's not really any automatic reminders that will tell you this client's been enrolled for a year completing an assessment. So that is something that projects need to be considering. It is possible within HMIS to set up like individual notifications on clients. So that's one way you can try to keep track of this. You can add a notification reminder that would pop up anytime you enter into that client's file in HMIS. So to say, like, you could set up the reminder to say income assessment due at whatever date. So that's one way to do it. Other projects would maybe just pull reports periodically. You could pull like an APR report and look at when people were enrolled and maybe do that at the beginning of each month and see who's going to be due for an annual assessment that month. There's a lot of ways to keep track of it, but it is important that you are tracking and staying up to date on annual assessments because timely completion of assessments really does directly impact performance outcomes. So, I mean, you can't get credit for things generally that are not entered in HMIS. So like if you've been working with a client and you help them to increase their income, that's great. But if it's not documented in HMIS, that's not going to be reflected in like performance outcome scores. So making sure you're staying up on top of all those assessments, including annual assessments, is going to be very important. So in addition to the HMIS assessments, projects should also be completing service needs assessments. So what do the regulations say? At a minimum, all recipients are required to conduct an annual assessment of service needs. So the annual or during program enrollment assessment in HMIS, or the comparable database if you're a DV provider, that does not satisfy this requirement. So you have to complete an assessment in HMIS, which again is looking more at like income, living situation, things like that. But then a project will also need to be completing service needs assessments. So these service needs assessments can look different. It's going to be probably dependent on the project of what they want that assessment to look like. But generally, you're trying to assess the things like what resources and skills and a participant like has available to them, and kind of what kind of barriers they may be facing and may need assistance with. And then obviously a service need assessments will then go on to inform like a case plan, that your service plan, you work with your client. So you have to do your assessment to figure out what your client needs, and then you work on a service plan with that client to kind of get them to a place where they can achieve that. So generally the minimum requirement is that you do it once a year. Usually that's probably not enough to stay on top of kind of what's going on with clients. I mean, stuff changes much more frequently than once a year. So really we recommend that you're doing some kind of service needs assessment on a monthly basis for rapid projects, or maybe a quarterly basis for permanent supportive housing projects. Again, that's up to individual projects to determine the kind of schedule they want to do those assessments on, but it is important to make sure you're kind of updating that information on a periodic basis. All right, moving on, we're going to talk about terminations now. So projects must maintain a formal written termination policy that recognizes the rights of individuals under due process of the law. So at a minimum, your termination policy should include information on both the voluntary and involuntary termination process, including what might trigger a termination. Your termination policy should clearly define the deadlines to respond to notices related to terminations. And the termination policy should also include instructions for how clients can appeal the termination decisions. And then it is important to note that in the appeal process for someone appealing a termination decision, the person or people reviewing that appeal must be different from the people that made that decision to terminate. So that includes like people in the same like chain of command. So if like a caseworker is working with a client and kind of reaches the point they think the client may need to be terminated, and then that gets appealed, that appeal will need to be looked at by someone other than that caseworker, and someone other than that caseworker's like direct supervisor. Like you need to make sure that clients again are able to appeal to someone that's not making that original decision. All right, so that's kind of what a termination policy should include. So what does a termination actually look like? So as we already kind of touched upon in the enrollment section, before anything has happened with the client with enrollment, they should be given a copy of the written project rules, the termination policy, grievance policy, and potentially any kind of lease or occupancy agreements that apply. So again, that needs to occur before they've been enrolled in the project. So assuming they're in the project, something's happened, and the project is considering termination. So the next step would be for the program to issue a written program violation notice that clearly explains like why or how the client is out of compliance. And then you should be allowing time for the client to correct that issue. I would also add that we would generally encourage that you may add some kind of verbal warning stage before the actual written program violation notice, just to hopefully address issues that won't prevent them from escalating to the point of needing to discuss terminations. But once you do issue a written program violation notice, you need to give them time to kind of correct that issue. We recommend that you give them like 60 days or so to come back into compliance with the program rules. So assuming that window has passed, the next step would be the program issues a written notice of termination, and that notice should include the proposed date of termination. And again, this notice should also relay the information related to how a participant could appeal that decision. Participants need to be allowed 90 days from the date the termination decision is handed down. They need to be allowed 90 days to appeal that decision. And if an appeal is requested, programs must provide a prompt written notice of a final decision to the participant once that case has been reviewed. So again, appeals cannot be looked over by people who are involved in that initial decision to move forward with the termination. And then, yeah, once that person or body that reviews the appeal has done that, you want to make sure that decision is relayed to the client as quickly as possible. For all of these related termination notices, we'd recommend those be hand-delivered notices. Whenever possible, you want to make sure this information is actually getting to the client. We understand sometimes maybe a participant has gone missing and you can't find them, and that's okay. But the best in best case scenario, you'd be hand-delivering these kind of notices. We'd also recommend that you are thoroughly documenting all the steps and events leading up to a decision of termination. For example, if a project has been unable to contact a participant for several months and is considering termination because of that, we should be able to look into the client's case notes and see like all the attempts that have been made to contact this person. You would not just want to see one entry from December saying we talked to the client, and the next entry from May of next year saying we're terminating them because we haven't talked to them. You need that evidence that you've actually tried to engage them in that sense. Yeah, I think that's it on terminations. And then related terminations would be grievances. So again, your agency must have a grievance policy in place, and that information must be given to clients. So grievance policy should adhere to the following. Projects must maintain a formal written grievance policy and provided to participants before receiving services, as we've already said. The formal grievance policy must be given to any participant who has been issued a written notice of program violation, which could jeopardize their ability to remain in the program. So basically, any kind of decision that's made that could impact the client's ability to stay in the project, a client needs the ability to appeal or file a grievance on that decision. So when a grievance is filed in a timely fashion, the consequences for whatever program violation is being appealed should be held off until that grievance has been completed. So if they've been given some kind of program notice saying XYZ is going to happen because you've violated these rules, if someone started that grievance policy, you need to put those consequences on hold until the grievance process has been reviewed. And then participants must be allowed at least 10 business days from the date of the notice was given to them to file a grievance. And then again, any grievance hearing must be held before a person other than the person who made or approved that decision. So same thing with the terminations, the people involved in those decisions to issue like a program violation notice cannot be the same people handling a grievance related to that notice.
I'm going to jump in really quick, Axton. I think before we move on to the next section, because we're kind of changing gears, I want to take a second to answer Lisa's question in the chat. So Lisa had a question that says, so if we have the annual assessment in the file, we have to do the one in HMIS as well? Yes. So there is an annual assessment that you have to do for every person in HMIS who is enrolled in your project for at least 12 months. I'm not sure what the annual assessment in your client file looks like. I imagine this might be more of like an assessment of service needs or like an annual update to their information. So what you have in your file likely does not satisfy the requirement that we're talking about in HMIS. So that is an HMIS specific assessment that you can only find in HMIS, and it walks you through exactly what the workflow. It's updating like their barriers, their income, their disability status, health status, things like that. You may have a form that you use outside of HMIS and document that in a file. That's fine, but you need to do the HMIS piece as well for anyone enrolled for more than 12 months.
So sorry, I didn't know if you had more on Lisa's question. I was going to address Michelle's question.
Yeah, go
She
ahead.
also did.
I mean,
Yeah,
I was
so-
gonna say on for Lisa's question, there we can direct to there is a bunch of like HMIS video trainings available, like if you kind of instruction on how to find or how to actually complete an annual assessment in HMIS. There are plenty of resources our HMIS team has developed, and we can get those to you if that would be helpful.
So I just want to go back to Michelle's initial question. So Michelle asked if we have updated termination, grievance, and VAWA notices. So we have template termination and grievance policies, but it is up to the recipient to maintain their agency level termination and grievance policies that are compliant with the federal rules. So chances are, if you have a termination policy in place, you've been monitored and it didn't come up into monitoring, you're probably okay. If you have not, and you want to review your termination policy or grievance policy with THN, we're happy to take a look at it. Similarly, we can also send the template documents that we've got as a follow-up to this call, just so you can compare it, against your existing documents there at the agency level. So the VAWA one is a little bit more complex. VAWA was reauthorized in 2022, and so we don't have updated VAWA notices. And I would have to dig around to see where the VAWA notices are. I think we have them in the policy and procedure file, but we can take a look at that one. They're not updated for the reauthorization, though. I will tell you that for sure. And then referencing the OSNIUM providing an annual assessment of client needs. So what is required in HMIS is not necessarily the assessment of client need. It is that what Hope was talking about, right? Like their income. What HUD is interested in is year over year, are you demonstrating a growth towards sustainability and self-sufficiency, or is there a flat line, or is there a decline in that person's income, access to income, access to healthcare benefits, disabling conditions? The HMIS annual assessment is really quite basic. The one that's more complex is the assessment of service need. That doesn't necessarily exist in HMIS. That's things where your case managers are setting like SMART goals, et cetera, with your participants to kind of move them towards self-sufficiency. So if they don't have income, that's where like a goal or a path to income would probably come into play. So I'm not sure if that helps, Michelle, but you probably won't see an annual assessment of client need in OSNIUM, and I don't think that there is an assessment of client need in HMIS. Thank you. So I know that we're getting a lot more comments on the chat, so I will stop
Jim, I don't
talking.
know if you saw that Denisha had a question as well. I'm trying to find it again.
Yep. Yeah. I did see that one. Thank you for reminding me. I've been leaning on the COVID brain excuse now for about 2 weeks, so I'm pretty sure I'm going to run out of time on that here pretty quick, but I appreciate you pointing that out. So the agency has a different policy and time frame for appeals. So as long as your policy is compliant with the federal regulation, that is what matters, right? Like when you say, does THN take this into consideration? If your policy is compliant with the regulations at 24 CFR 578, which is the interim rule for the continuum of care program, you're good to go. Now, what we have on the slide is compliant with the interim rule and what we believe to be best practices based on what other COCs are doing. So, I think in terms of taking it into consideration, we're not passing judgment one way or the other, as long as your termination policy and grievance policies are consistent with the federal rules. Does that help, Denisha? So in other words, your agency can absolutely have a termination policy and grievance policy that are somewhat different from what we're presenting here. Great. All right, thank you.
All right, so next we got a poll question here as we move into the next section. So if you want to go ahead and share your answer in the chat. The question is, in what instances should homelessness documentation be accompanied by staff's documentation of due diligence. So is that when an intake worker provides documentation of homelessness, or when a third party provides documentation of homelessness, or when a participant self-certifies their homelessness, or are all of the above required to have documentation of due diligence? All right, there we go. So it looks like the answers in the chat got it right here. So documentation of due diligence is required when a participant self-certifies their homelessness. So in general, intake staff must make conscientious and reasonable efforts, also known as due diligence, to obtain third-party documentation whenever possible. However, an intake worker must never contact someone for third-party documentation if the individual or family believes that their health or safety will be jeopardized by contacting that person. In these instances, the intake worker should document the individual or family's feelings and statements in the case file. If third-party documentation is not available, intake staff must document the due diligence efforts and the reasons that prevented them from obtaining third-party documentation in the case file. The due diligence documentation must be signed, dated, and certified by intake workers that is true and complete. And HUD does not require emergency shelters, street outreach, or victim service providers to obtain third-party documentation.
Thanks, Exton, and thanks to all who were brave enough to answer the question in the chat. We promise we are not grading y'all. We're just trying to get a pulse on everyone's understanding. So thank you for that. So I think we're going to spend the rest of the time in today's session talking about documenting participant eligibility. As you can see, I've got some pretty minimal information on this slide. I'm going to take us through the eligibility packets. We did just the rapid and the PSH packets are basically identical. So I'm going to review the rapid one, and you're not going to miss anything by, if you're a PSH provider, I'm going to cover all the content you need to know for PSH. For rapid, I'm going to make sure to point out the things that you don't need to cover for your project type. But really the only difference between these packets is the name of the program. Again, I'll highlight the differences as we're going through them. So we did just update these forms just this week for clarity, not for content. So if you've been using the old form, that's totally fine. That form is still okay to use. I would recommend, though, downloading the new form available on our website. I'm sure we can get those links dropped in the chat too. They've just been updated for clarity, and really just some of the instructions have been updated a little bit. So with that, I'm going to stop sharing this, and I'm going to pull up the eligibility packet, and we can go through that together. Hopefully everyone is seeing the eligibility packet okay. If not, I'm sure someone will let me know. This document should be familiar to you if you've been in your program for a while. The normal version is not covered in highlight and red text like this one is. This is just an annotated version for the purpose of this presentation. So before we kind of get into it, I see a question: what does due diligence look like? We'll be talking about that a little bit later in this section, Michael, so stay tuned. So before we get into the content of this packet, I did want to do a plug for HUD Monitoring Exhibit 29-1, review of homeless record keeping requirements. So generally, when you are monitored by HUD, that typically includes a review of client files, which generally includes a review of your homelessness documentation using 29-1, I don't think I've ever seen a monitoring that did not include Exhibit 29-1. And so I think what is most important to communicate here is that when your HUD rep is monitoring your program for compliance with homelessness record keeping, they're not just looking for evidence of the verification. They're looking for that the verification is consistent, that the dates match, that the details all align, and that there's consistency across all of your forms. So it's not enough just to have a packet. It needs to be consistent and it needs to be verified. Looks like Axton dropped that link to the monitoring exhibit in the chat. That's also linked later in this presentation if you'd like to review that later. So I'm not going to go through this line by line. I'm just going to highlight some things that I think are important. And then if you have specific questions along the way, just drop those in the chat. But I would highly recommend taking some time to read these instructions in their entirety before you use this form. When we review files here at THN, really any errors or discrepancies that we identify are a result of not thoroughly reading the instructions or following the instructions. I recognize that there's a lot of information here, but it's important that you take some time to familiarize yourself with what is expected in these documents. So again, review the instructions before use. I did want to highlight some new guidance here for in the homeless verification section of this tool. So we did add a note that Part 2, the chronic homelessness status, and Part 3, disability sections of this form is only required for permanent supportive housing providers or rapid rehousing providers that are enrolling someone into their project with the intent of later bridging them to PSH. So that I'm talking about this page specifically here. So again, Part 2 and Part 3 is only required if you are a PSH provider or a rapid rehousing project bridging from one project type to another. So it's not required to do if you're a rapid rehousing provider. And I recognize that like not every community has a PSH project that they can bridge someone to. So if you don't need to do chronic homelessness verification, I would not recommend filling out those parts of the packet. Other things to highlight on this page. Users will need to attach additional supporting documentation such as HMIS records, third-party homelessness verifications, or intake worker observations. So in some scenarios, it's not enough to just simply fill out this packet. You have to attach supporting document depending on the type of certification that you're using, and we will talk about that as we're moving through it. I did want to highlight here the order of preference. Particularly HUD's order of preference that homelessness verification is obtained in. Starting with third-party verification is the first preference, followed by intake worker observation, and then lastly, applicant self-certification. It's important to note here that your agency and your program must have written intake procedures for documenting homelessness, including the order of priority that documents will be collected in, and the documentation that you have for each client should align with your procedures. So if third-party verification is your top priority per your policy, which it likely is, then your eligibility packet should show that that was what was attempted to be collected first before moving on to the second priority. And I do want to point out that if you have not taken some time to read through these FAQs, I would highly recommend it. There is a lot of good information buried in this packet that is really valuable, and I feel like really helps clarify some of these points in pretty clear language. So I would definitely recommend spending some time doing that. We don't have another section on intake worker observations in this packet. There is a section in the PowerPoint, so I wanted to take just a minute to talk about what that looks like. So intake worker observations must be on agency letterhead and must clearly articulate in their professional judgment that the individual or head of household was residing in a place not meant for human habitation or an emergency shelter at the time of intake. And again, that should be collected in alignment with your policies and procedures. And then I also wanted to highlight, you may need, if you're a PSH provider or a rapid rehousing provider that wants to bridge a client to PSH, you may need multiple third-party verification forms. And actually we would expect that there's multiple, and there doesn't have to be in every case, but it's not often that one verification form can certify an entire 12 months of homelessness, though it does happen. So we would expect to see multiple forms when it comes to establishing chronic homelessness. Again, these FAQs have a lot of really good information on what that looks like. There is also like a whole separate packet that HUD has related to documenting chronic homelessness that I'm sure all of our PSH providers are familiar with, and I believe that's linked later in our presentation. So moving on to documentation of due diligence, we'll be talking about this a little bit more later in this packet, but folks should document all their efforts to collect third-party verification, including the client or applicant's current living situation and why the attempts were unsuccessful. We do have a specific due diligence form linked in this packet that we'll walk through together, but wanted to highlight that here. Regarding self-certification of homelessness, this should always be a last resort, unless you're a victim service provider. But non-victim service providers should always be using this option as a last resort. There are some other considerations for PSH providers using self-certification that we'll be talking about when we get to that form. So for PSH projects specifically, or for rapid rehousing projects specifically, if you are not trying to document chronic homelessness status, you are not required to fill out the disability verification form, even if your client has a disability. That's only requirement for PSH projects. So it's likely that you might be serving someone in a rapid rehousing project that does have a disability, but you do not need to complete that form, and that should not be a barrier to entry for rapid rehousing projects. But if you are a PSH provider and are trying to document disability, there is a form linked later in this packet that we'll talk about. That is one method of documenting disability. Another method, and really the preferred method, is if the applicant is receiving SSI or SSDI, then retaining a copy of that award letter or a copy of a disability check, ideally within the last 12 months. And then a new piece of guidance I wanted to highlight is specific to the disability verification. We can talk about that more when we get to the form itself, but these are new instructions for this form that essentially say if the applicant's qualifying diagnosis is HIV or AIDS, then they are not required to satisfy the 3-part test at 4A, 4B, and 4C. So less questions to answer if the qualifying disability is HIV or AIDS. Moving on to the homelessness verification and chronic homelessness verification form. Again, this must be supported by accompanied by supporting documentation. Completion of this page alone does not satisfy the requirement for documenting homelessness. It needs to be accompanied by additional documentation. So again, if you are a rapid project, you do not need to worry about part 2 or part 3, but these are required for PSH projects. And I do want to highlight that how you fill these out should be consistent throughout all of your documentation. So I think I kind of said that in the monitoring piece, but really there should be, your documentation should paint a very clear picture of the client's homelessness situation with consistent dates throughout the documentation. And if those dates don't match, or if there's conflicting information, that can definitely raise some eyebrows during a monitoring. I know we're running short on time. I do want to make time for Q&A at the end. But looking at third-party homelessness verification, this can only be completed by someone who has personally witnessed the applicant's homelessness. So if you're an intake worker and your only encounter with this person trying to receive assistance is at the time that they present for services, then your observation would not qualify as third-party documentation in that specific scenario. I want to highlight these FAQs here that have some really good information about what that looks like. So this does have to be completed by someone who has personally witnessed the applicant experiencing homelessness. And then these forms do need to be, depending on which box you're checking here, might be accompanied by some additional records like HMIS records or other forms of third-party documentation. It is important to make sure you are checking one of these boxes to indicate how this form is being filled out. And of course, it needs to be signed, and this needs to be consistent. Again, so this should be consistent with the information on page 3, the homelessness verification form. And again, PSH projects may have multiple third-party verifications to fully satisfy their documentation requirements. For self-certification, again, whatever you put here needs to be consistent with the page 3, the homelessness verification form. So something to consider as you're filling this out. For PSH projects, no more than 25% of persons enrolled at any given time can have more than 3 months of self-certified homelessness. There's some additional guidance on this specific requirement that I don't think is linked elsewhere in this presentation. I think it's likely linked in this document, but if it's not, we can share that in the follow-up materials. But this is not applicable to rapid rehousing or joint component project types. So PSH only. So this section is optional for PSH or for rapid rehousing providers. You do not need to certify chronic homelessness for a rapid rehousing or joint component project. And then the applicant statement should include the location and period of homelessness. This can be completed by the client, but it can also be completed by the worker with the assistance of the client if the client completing it on their own creates an undue burden. So if they have limited reading and writing proficiency, you may want to fill this out with your client and have them sign it. I see a couple questions in the chat. I think we'll get to those in the Q&A session. We just have, I think, 2 more pages of this document to get through, and we'll move to Q&A. So regarding documentation of due diligence, this form should be completed anytime a participant self-certifies their homelessness. Again, it would take some time to read the instructions, but you need to clearly lists the client's name, the date, the name of the third party, and their title. So who you're trying to get that information from, when they were contacted, how they were contacted, like what methods you used. And then you need to include details and dates about the client's current living situation. And then describe your attempts to obtain third-party verification and why they were unsuccessful. So there's an example here that I've included. It's also listed elsewhere in this document, so you have that for review. But this is an example of how you can satisfy this requirement just by simply saying, on these dates and times, I reached out to this entity to try to obtain this information and have not received a response. We'll move forward with the self-certification, but we'll continue to try to contact the entity who could verify the third party. And then if that is gathered, then the form will be updated. Again, needs to be printed, signed, and dates should be consistent across these forms. Disability verification only required for PSH or bridging to PSH. Like I mentioned earlier, this does not need to be filled out if the client provides a copy of an SSI or SSDI award letter or a copy of their check. As a best practice, these should be dated within or no older than 12 months from the time of obtaining the documents. So this specific question is new. I highlighted this in the instructions, but if their qualifying disability is HIV or AIDS, you do not need to satisfy the 3-part test at question 4. So you can just skip over this and leave it blank. This is a new addition to this form. So it would be mindful as you're filling this out and as you're instructing providers to fill this out is something I would highlight here, that they do not need to answer question 4 or the sub questions beneath that. And then if you do use this form to document disability, it does need to be signed and completed by someone who is licensed to diagnose and treat that condition in the state of Texas. So if it's a mental health condition, you generally have some more options available to you. It could be an LPC or an LCSW or a physician or a physician's assistant. Obviously less options when it's a physical disability, but there are a number of providers who can diagnose and treat disabling conditions in Texas. So I know that's a lot of information to move through really quickly. I see a couple of questions in the chat. I'm going to go back to our president.
Yeah, I think Lisa had a question in terms of whether or not this is new guidance. And so the answer to that question is that no, that HUD has also always required, well, I shouldn't say always, but since about 2016 or 2017 required this this idea of a third-party verification and establish that order of priority that they want to see verification documented in. I can tell you that for rapid rehousing projects, it's third-party verification is less paramount compared to permanent supportive housing. So it would be hard to say whether or not a file from a year ago would need third-party verification or if it would need some additional assistance or like to revisit that file. The idea is that you, in your policies and procedures, have a documented order of priority so that you are always going after third-party verification first. If you cannot obtain third-party verification, then you can move on to the intake worker observation. And then if you cannot obtain intake worker observation, moving on to self-certification with the documentation of due diligence. You don't need documentation of due diligence for intake worker observation, but you do need some form of establishing that the participant that you're enrolling is eligible You just don't have the same restrictions as a permanent supportive housing project where you can only have 25% with more than 3 months of self-certification and having to have 12 months of documented homelessness, et cetera. So I don't know if that answers your question or not, but I just wanted to jump in there and try to address that one relatively quickly. Yeah, it doesn't, if you use this intake packet, then it can be on the intake packet document itself. It doesn't have to necessarily be on their third party letterhead, especially if you're completing it on behalf of a third party. It should probably be, if you're getting it from another organization. I mean, it would make sense that it would be on another organization's letterhead. I don't know that that's like a requirement that would get called out in a monitoring. And Hope, I don't know if you want to address Courtney's, but I think those are really the main two. And I don't know if we addressed Michael's question through the review of the document itself, but we might want to revisit that one as well.
Yeah, Michael, I don't know if you have any follow-up questions after hearing that information, but I'll give you some time to ask that if you do. Courtney, I see your question. So are you stating if there are 4 episodes of homelessness, that each episode needs its own verification form? No, it doesn't need its own verification form. It just, sometimes there are multiple parties verifying different episodes. So if there are multiple parties verifying different episodes, you would need different forms. But if it's the same person verifying each episode, that can be on one form. And then, yeah, by HMIS documents, exactly what you stated. So printouts of emergency shelter stays, emergency shelter records. I'm not sure if any other services or records in HMIS would satisfy that requirement. Jim, I don't know if you know that, but I know emergency shelter stays are the most common one.
Yeah, if there's like a day shelter in the community that's participating in HMIS, that could also count. I think there's an FAQ specifically about which HMIS records will satisfy that documentation requirement. You don't need like every HMIS record that they've ever had. You just need enough, if you're talking about rapid, to establish that they were homeless whenever they came to the program. And if you're talking about PSH, you need 12 months worth of documentation. And I think the standard is at least 1 day out of each month in an emergency shelter satisfies that documentation requirement. Certainly if they have more than that, I mean, you want to kind of build the case because the ramifications of them saying, oh, this is not sufficient. But I believe there's an FAQ that again establishes that, 1 episode in a month establishes homelessness for that month, and for the purposes of documenting 12 months of literal homelessness. Now, the back end of that is like, if you know as a professional that someone had 1 stay in emergency shelter, but then like got an apartment and was in an apartment for a month and then came back to the emergency shelter, like there's a break in homelessness there. So I think there's some degree of professional judgment about how you use the information to build a honest and truthful case, if that makes sense. Not saying that anyone would pad a history to get somebody into PSH, but you do want to be cognizant of that.
Yeah, thanks, Jim. I know we just have 2 minutes left. If there are other questions, we can continue to take them. There are a couple slides left in this presentation. I'm just gonna briefly note. There are a few slides about documentation standards I'm not going to talk about because we covered that in the review of the packet. They are simply included here so that when you review this information later, you have it in writing, since I gave that information verbally. And that is all of these homelessness documentation standards slides. So I just wanted to note that we're not going to cover them outside of the review of the packet. But I did want to highlight some resources. So it looks like we've shared the updated links to the packets in the chat. Those are also linked here. We'll send that out when the recording is available. Always going to link our written standards and the monitoring handbook whenever we can. There's also The CoC virtual binder is a really good resource if you are new to documenting or homeless eligibility or want a refresher. There's some modules and some built-in quizzes that are really helpful and some additional documents. Additionally, there's a really good training through HUD Exchange that is free that you can access after creating a HUD Exchange account, and that is linked here. And then we've also linked our HMIS training videos related to updating annual assessments. And then just our general YouTube playlist for HMIS related training. I know our HMIS has had probably a dozen updates since this training was put out. The content should all still be the same. The user interface might look a little bit different, but content is still there. I know we are right at time. If there are any questions, we can stick around for a couple more minutes and answer those. I'm going to stop sharing my screen. Contact information is linked in here. Everyone should have our contact information. I will share mine in the chat just in case you don't know how to reach me. And with that, I think that's all we have unless there's any other questions. If you don't have any other questions, thank you so much for your time today. We appreciate y'all showing up and asking lots of really good questions. And I hope y'all have a great rest of your week. Again, if there are questions, we can stick around for a couple more minutes.
Don't forget about the public comment, and don't forget about the 16th. We're going to do another kind of lunch and learn style 1 hour rapid fire training on March 16th. So I hope you'll join us for that. And then if you have any questions about the policies up on the website, please feel free to reach out to me or Hope or Axton directly. So thank you all so much.
I don't see anyone typing in the chat, so I think we're safe to go ahead and end the presentation. Thanks, y'all.